all to the fifth presentation, AZNHA's conference series. For those of you who don't know who I am Zach Shaw, the president of AZNHA. Just to let you know, you've all been muted to avoid noise disruptions during the session. And we will be recording, as Linda said, to post on our website in the members only section later. And before we get started with Angelo, we do want to thank our conference presentation series sponsor, SanData, for supporting AZNHA and this series. Steve Polito, SanData's Senior Vice President of Provider Sales, is here to share information about SanData. Steve, go ahead and take it away.
Thanks, Zach. I appreciate it, and thanks, everyone. I don't want to take up too much of your time here, but I did want to just say a few remarks. If you're not aware, we've been members of AZNHA. We've sponsored this series and a couple other prior events. We've done speaking engagements. So always appreciate the opportunity to say a few words. Really assume everyone on the line probably knows us as the state's EVV vendor, the awarded vendor under the mandate. Many providers, though, and we have that position in a number of markets across the country. And we often find that providers don't realize that we have more than just EVV. We have a full agency management platform as an alternate vendor option. That includes, obviously, integrated EVV. We've got advanced scheduling. We've got an integrated payroll solution. So long story short, we're bringing a ton of new innovation to market. We just released an e-learning. We're working on an eligibility platform. So in summary, just the long story short is we appreciate the opportunity to be a part of the association. And if there is interest in evaluating a new software platform, we'd obviously love the opportunity to explain what we have to offer. So appreciate that, and I hope you enjoyed today's session.
Thanks, Steve. And as always, we really do value SanData's partnership and support throughout the years, and look forward to continuing that partnership and support as years to come. So thank you again for sponsoring this series. Now we're going to move on to our featured speaker. I've got the thing just popped up, and Angelo screen popped up, so got rid of my script there for a minute. But
Angelo, sorry. You want me to stop sharing?
No worries. No, I know who you are, and hopefully everyone on this call knows who you are as well. But just real quickly, Angelo with Littler is here to speak. Littler, they're famous for their home care toolkit, and they also have a COVID-19 toolkit. If any of you have not looked into that or didn't log on early enough to hear the dialogue with members, it's pretty essential for us to run our businesses and with best practice. I mean, it'll save your butt over and over again if you run into legal issues or have any questions and want to kind of fine tune your operation. So with that, I will let Angelo take it away.
Thanks, Zach, and thanks everybody for joining. I think, if I'm not mistaken, there's some extra time here. So if you all have questions, I think it's kind of budgeted for an hour. I'm happy to stick around. I've got my next call is at 4:30 my time. So I can go till about 4:25 or so. So I've got some slides. I think with this size audience, I'm happy to answer questions as we go. So feel free to chime in. This is my contact information for anyone who needs it. I can't quite tell in presentation mode who all is on. Hopefully we are working together already, but if not, that's my contact information. The resources that you have that Tom was referring to are really good. One is an FAQ. I mean, if you don't know us, we are. I'm the co-chair of the home care and home health practice group at Littler, and this is all I do is home care and home health and compliance and a lot of litigation and basically anything home care related we are involved with. So the FAQ that you have is basically a breakdown of all the COVID related issues, CARES, PPP, PPE. Everything that has passed, basically providing guidance. What do you do when somebody's sick? What are the quarantine rules? And those FAQs update as the CDC guidance updates, as things are changing and new law is on the books. The FFCRA is covered in great detail there, and all the machinations of the healthcare provider exemption. We'll talk a little bit about that today. And then the recommended protocols is something that we put together. It was several of the big brands, national brands, who worked and lended us their chief clinical officers and their expertise, along with our work and research on defining sort of recommended protocols to put in place to protect your clients and your customers, and in turn protect your agencies from potential liabilities. So what we'll cover just kind of a nutshell. I'm assuming that some of this, what the election results were, what they appear to be, what's still sort of outstanding, what the outlook is, and really most specifically how that might impact our industry. We'll talk a little bit about where we're going, what might be happening with the fourth round of stimulus, and what the differences have been historically between the Democrats' proposal and the Republican proposal, and what that might mean. We'll talk again about the FFCRA and the healthcare provider exemption, where that stands, a little bit on litigation and proactive steps, and then you've got the recommended protocols. I'll just talk about that. So we'll start with it. It seems as though, and has been called, that Biden is the champ here. A couple of states are still waiting on. I think we know where Alaska's going. Georgia's very, very close. But it looks like despite what President Trump may be arguing, that this is going to be a Democrat in the presidential suite. So with respect to the House, it looks like the Democrats will maintain control, but by a narrower majority than previously. And I think that this, along with what has happened with the gubernatorial races around the country, is sort of an indicator that what the Biden vote appears to be is more an anti-Trump sentiment than a pro-Democrat sentiment, or we would have seen sort of the blue wave that was predicted by some. This right here is really where the action is in the Senate, and this is going to be so important, what happens in the Senate, and frankly what happens in Georgia, where it looks like we've got 2 runoff elections for seats, and whether those seats are Republican or Democrat is going to go a long, long way in determining what happens over the next 4 years and how much happens over the next 4 years. I think we have an indication of what the policy will be and what the efforts will be, but when you have a Democrat as the president and a Democratic House, if the Senate is also Democratic, and right now the net change is 1 + 1 Democrat, then there's no obstacle to passing legislation if everybody votes along party lines. So you have probably seen that the Georgia runoffs are going to be the most expensive state legislative battle in the history of the United States. There's going to be so much money spent on that because of the significance. Really amazing. You all know what happened in Arizona better than I do, but it looks like Biden by a narrow margin, and then you had Kelly, but the Republican stayed in the House. And we talked a little bit about Proposition 207 and legalizing marijuana, and that was a relatively overwhelming response with a 60% vote. So that is consistent with what we've seen in other parts of the country. It's becoming very challenging, and one of the themes of tomorrow's kind of election analysis, which you guys are getting a preview of some of this, because a lot of these early slides we're using, is that for the national providers, for people that are in multiple states, it is becoming very, very difficult to keep up with all the changes. You've got now federal law changing frequently, state law changing frequently, And then you have these sort of these referendums, like what happened in California, and direct democracy is the way folks refer to it, where the population is now creating new law as well. So it's very, very challenging as companies have to try to navigate all of these changes and run their business. So what happens now? We'll have a new Congress sworn in January 3rd. There's going to be work, though, that is immediately being done. I think the very first step is going to be the additional COVID package, and we'll see whether that happens under the Trump administration, sort of as a last blast, or that happens afterwards. I tend to think that we're going to see something sooner rather than later, now that the election results are relatively clear, and it will probably be more like the HEROES bill than the HEALS bill. If you remember HEROES, and we're going to look at this in a little more detail, HEROES was the legislative package, the fourth stimulus package that came out of the House, and the response, it was basically DOA in the Senate, and then the Senate had a response that was HEALS, a much slimmer version, and they're several $trillion apart. Since that time, there had been negotiations with Pelosi and Mnuchin, the Secretary of the Treasury, and then later Pelosi and McConnell, trying to get this all resolved, and various degrees of success. We'll talk about what some of the key points are there and some of the obstacles. What else we might see is extended FFCRA coverage. I think that's probably likely. We're going to talk about what has happened so far, so everybody's familiar and knows what to do with FFCRA. But I think we really need to watch that, because some of the exemptions that exist, my guess is they probably go away, or there's going to be an effort to take them away. Like, for example, the 500 employee threshold, and the healthcare provider exemption. I think that we might see extended unemployment, hazard pay, and a lot of money going to the states, which that was all in HEROES. So with respect to labor and employment policies, Biden has already come out and said that it's essential that we get the pandemic under control. That's the number one goal that he has immediately. The pandemic, as you all have seen, I think we're over 10 million cases now in the U.S., and we've got daily records that are being set. So hopefully this vaccine is real and we can get it out quickly, because we're going to be in this for the long haul. Otherwise, I don't see the coronavirus going away anytime soon. So we're going to need some kind of ability to really curb the spread. The joint employer rule, this matters a lot for our franchisors and the franchisees. I saw that there are several franchisee owners that are on this call. This is the two major issues that I see from a labor perspective, are the joint employer stuff and the independent contractor stuff. And so with joint employer, there had been some progress, basically separating the concept of joint employer for everyone's benefit, is the idea that you can be held liable for actions of the statutory employer because you have too much involvement in the business. And that can apply when you're talking about an owner, right? The owner is often named in a case. For example, the Department of Labor will name the owner of an agency and argue that they are liable for the actions of the agency under a joint employer theory. Also, franchisor, franchisee, parent, subsidiary, staffing from a staffing perspective, the company that's doing the staffing and the company that is being staffed can be deemed joint employers of the caregivers that are staffed. So there's a lot of ways in which that plays out. and it is very likely now that there's going to be quite a bit of an effort to dial back some of the progress made on joint employer, such that there are more, let's say, pooled liabilities across entities and individuals, and that's not a good thing for anyone, except for the government, because now the government and plaintiffs' lawyers have an easier way of sort of establishing liability without considering, the corporate entity and kind of some of the separation and the corporate veil that, these type of arrangements were designed to protect against. Same thing with independent contracting. We saw, Proposition 22 pass in California. That's the one about Uber and Lyft, and allowing those workers to continue to be treated as independent contractors, but with some additional benefits. And that's very significant, right? The idea of almost like a hybrid worker, that is contrary to what California had been doing, which kind of demonstrates, where things stand with respect to the democratic nature of California, right, where the politicians are running the show, bought by interested parties that aren't necessarily representative of the actual population, because that passed pretty handily as well. So we'll see what happens there. I think in California there's going to be a ton of litigation over AB 5 and Prop 22, but I think generally what we're going to see is independent contracting get challenged a lot more, which in our business is going to affect the registry model and the virtual marketplace, right? And there had been, at least at a federal level, a lot of softening around independent contracting, a field assistance bulletin. I'm going to go into this a lot more tomorrow, but I think that's going to change. Some of that might get repealed, and I think we're going to see some standards that are more stringent in requiring W-2 employees. Now, how far that gets is going to be, and this is why I said that the race in the Senate is so significant, because if the Senate is Democratic, then you're going to see legislation around joint employment, legislation around independent contracting. If the Senate holds Republican majority, then you'll probably see executive orders and some regulatory changes that are not as long lasting. We're also going to see more laws and regulation around narrowing the pay gap between genders. We'll see more regulation generally. There was a ACA challenge that was heard by the Supreme Court today. I haven't gotten a report yet, but we're going to cover that tomorrow. Which is really, that's going to be huge. If the Supreme Court basically overturns the ACA, then healthcare coverage is probably going to be the #1 issue moving forward, even more so than anything else we've talked about, other than maybe the pandemic relief, the forced stimulus package. Question, or was that just somebody talking?
Oh, hey, Neil, I am good. I'm glad you called. I'm in the middle of a webinar, so I have just a quick
got to
minute.
mute.
But
I'll
I
wait
am
1 second,
glad you
because I don't think
called.
you're all
Let
going to
me
hear me.
pull up my email and refresh myself on my
Zach, probably could use you here. All right, great work. Okay, so extended recession, I think is probably likely, which is going to put a lot of pressure on the unemployment systems of the states. There will be a big fight for $15 an hour for the minimum wage. Again, Senate, what happens at the Senate will be really big there. Florida actually passed one of these referendums to the population did to increase the minimum wage to $15 over time. It rolls in after several years of gradual increases. We're going to see a lot on paid sick leave. That was a real initiative of the House many times over, and then the FFCRA kind of came in, and the original proposal for paid leave benefits was a permanent one. That didn't fly, and then we got the FFCRA, which was a temporary one, but now there's some, some tolerance for that. So I think you are going to see a push for more permanent leave. We are definitely going to see more workplace safety standard with OSHA regulation, and probably some more draconian penalties for violating OSHA, the new OSHA standards that we will see. The unions are going to have a more powerful voice, just like employers over the last 4 years have gotten a lot of play and a lot of ability to get some of the initiatives that the employer community had. I think we're going to see that now with organized labor, so you can expect that. Biden has already talked about funding the Department of Labor to have more investigators out in the field. I mentioned at the beginning of this that home care is already quite a targeted industry by the Department of Labor. I expect that to continue. And as mentioned, I think the FFCRA, we might see that extended, and maybe some of these exemptions may go away. So you all may remember watching the associations, identify these 5 target goals. So let's just kind of talk about how these might play out in the next stimulus package, now that we have some visibility into what the election results will or are and are likely to be. I would add a 6th one to this now, and I'm going to be talking to the associations about this, and I think everybody should be clamoring for this, is that vaccination, and what we were saying in the beginning about getting home care prioritized and home care workers prioritized to receive vaccinations, putting aside the issue for now, whether that's just an election to receive a vaccination or a required vaccination. I think we need some clarity around that and some priority around that. So let's take a quick look at heels versus heroes without getting into too much detail. This sort of points to where the major differences are, right? And the Republicans, their package had a lot more built into small business aid, right? A lot less to the states, a lot less in unemployment benefits, right? And you can see the major difference is the state aid, and that's why I'm saying that what we likely see now that we have a Democrat as the president, we're going to see something that leans more towards the Democratic plan. But let's look at what that means with respect to the issues that we care about. It might not be a terrible thing when you think about the Heroes package, aside from all of the money in the Heroes package. And we're not going to see exactly the Heroes package, but maybe something closer. Paid childcare was in there, hazard pay that was paid by the government. If you remember, hazard pay being paying first responders, paying people, and home care, by the way, was included in that. The home care caregivers were part of the group that was supposed to receive hazard pay. So I think we're going to see that resurrected. The FFCRA coverage is part of Heroes, extending that pool and funding for PPE, unemployment being extended at a higher level under Heroes, sick leave, more PPP loans, and the big difference was the immunity, right? And Tom alluded to this. Immunity was in the HEALS Act, and if you remember, HEALS was broken down into several different sub-legislation, with the idea is maybe we can pass some of it, and even if there's some that's controversial. And the SAFE Act was the one that dealt with immunity. It was very, very strong, really healthy immunity. I don't think we're going to see that, not at that level. I loved what the SAFE Act was doing, because it actually gave you a right. If somebody brought a claim that you were immune from, a lawyer, you would actually have a remedy against that lawyer, which you never see, right? When you imagine, suing the lawyer and getting your fees, right, covered for that frivolous lawsuit, that would cut down these cases entirely. And I do think, we'll look at litigation in a minute, I do think that the threat of immunity has slowed the COVID claims that we've seen a little bit. I think, because the immunity that was proposed would have been retroactive. So I think that it has had an impact, and now we'll see where that litigation goes now that the threat of immunity is less than it was. So I had mentioned that there is some qualified immunity in Arizona that extends through December 31st. That's through Executive Order 2020-42, and it provided immunity to hospitals, nursing homes, and home health and hospice agencies, but not home care, not the non-medical home care. And it was related to gross negligence and reckless and willful misconduct that wouldn't be covered, right? So just general good faith actions and general negligence, right? So if you could have done something better, that the immunity will still apply to you. There was a bill 2912 that was designed. Again, I'm sure you all know this better than I do, around creating the same kind of immunity for all businesses that passed the House but did not pass the Senate. So that's good for at least some of you, that at least you've got some protections at a state level. But what I would tell you, the whole idea behind those recommended protocols that you have, right, is to help you avoid these wrongful death kind of lawsuits. We're seeing a lot of those sort of suits. The good news is I don't think those suits are particularly viable. I think it's very, very hard to win a wrongful death kind of lawsuit. There's a lot of worry about wrongful death lawsuits. I think too much worry. There's more worry than there is legs, because they're difficult. If you are doing what you should be doing, you're following those recommended protocols, you're training your caregivers, you're screening your caregivers, right? You're using the notices and the types of things that are in that FFCRA package and the COVID response package that we're talking about, providing leave for people who are sick or at least having them quarantined. You're going to be in good shape. And it's not that a lawsuit won't be filed. It may be that a lawsuit is filed against you, but your odds of success are very, very high. Very high if you're following those protocols and taking those steps. So just double down on that, continue to double down on that, continue to communicate with your caregivers and clients about what your response has been, and continues to be, and make sure that you are up to date on the latest guidelines. Just like the FAQs, those recommended protocols are updated every time the law changes, then reviewed with the steering committee, all those brands I mentioned, and then passed out to the public. So hopefully you all get my client alerts. I sent one Monday, and I think the one on Monday had the latest recommended protocols. You've got them here, but if you didn't get that client alert on Monday, let me know. It was Monday, probably your time around 2 o'clock or something. Let me know, and we'll make sure that you're on our list so that you get these updates as they go. We also talked a lot in that client alert about the FFCRA. So let's talk for a minute about that. Do you guys love how fast I can talk? I'm getting better at this because I've got a lot of slides here, and I don't know that I'm going to get to them all. So FFCRA went into play April 1st. Remember what it does, and the FAQs cover this in great detail, so I'm not going to cover all the details unless somebody has a question. But 2 weeks of paid sick leave, and there's 6 qualifying reasons where you might a caregiver might qualify for paid sick leave, all around exposure or dealing with a child who is out, and you have a primary caregiver who has to care for a child due to closures that relate to COVID, right? And then you have paid family medical leave, right? And that's an additional 10 weeks, and there's only one way to qualify for that, and that has to do with the taking care of the child, right? And that's what the industry was super worried about, very concerned, is we can't have people on the bench for 12 weeks because their kids are out of school. We really need our caregivers out taking care of our clients, and we just don't have the bench strength to accommodate that. It wasn't so much the money, because you get a tax credit for this type of leave, right? So you're not paying for it, the government is, but can you really afford to have people out for that long? The paid sick leave did not present the same kind of problems for folks because everybody agrees that if somebody's sick or they've been, they need to be quarantined, we want them out of the workforce, and we don't want them incentivized to work because they wouldn't be paid otherwise. So let's get them some money to sit on the sideline until they're ready to come back into the game. The FFCRA only, as of right now, covers employers that have less than 500 employees, and there has been a lot on this issue of who is a healthcare provider. There was an exemption. There still is a limited exemption for healthcare providers and for employers who have fewer than 50 employees. One mistake that a lot of small agencies make is they say, well, I have less than 50 employees, so I don't have to comply with the FFCRA. That's not true. You don't have to comply with the leave related to school closings or childcare unavailability, not the other ways in which somebody could qualify for paid sick leave. You still have to comply with that, which you should probably want to do anyway. Again, I'm not going to cover all the details here because I've done this a zillion times, and there's lots of recordings on this that are both on the toolkit, on NAC, on HCAOA sites. But this was the original reg. I just want you to basically understand the timeline of what happened that the DOL put out, and they had a very broad definition as to who was a healthcare provider. We actually worked very, very closely with the DOL to try to get a broad definition on behalf of all of home care and get home care basically a seat at the healthcare provider table, so to speak. And the DOL did that. We originally were trying to get this in the FFCRA itself, where the statute would define what a healthcare provider was. Unfortunately, that's not what occurred. So regulations can be challenged, and that's what happened in the case in New York. And basically, one of the arguments that was made by the New York state and a bunch of other states as well joining in on that lawsuit, the attorney generals, was that the healthcare provider definition was too broad, and the court agreed. The district court agreed with the state of New York's argument, and basically the DOL lost on every ground. That what that means is there were several of the instructions, regulations provided by the DOL, including that healthcare provider definition, that was struck and lost. And what that then did is it reverted the healthcare provider definition to the original definition that would have existed before the DOL did anything at all. And that definition is extremely narrow. You see it on the screen here. It would not apply to almost all home health, home care, hospice, right? Generally, it's not going to cover your caregivers. Very, very specific and detailed definition. And what people don't always understand is because what the Department of Labor did and the Department of Labor's regulations be vacated, that means that they never existed under the law, and this definition was in place the entire time, right? And so that means that if you were using the healthcare provider exemption, because the DOL told you could, you face some potential liability. And you may remember, if you've been on our presentations, we kept talking about get a legal opinion that you're a healthcare provider. That legal opinion was for the purposes of if this happened. We thought that this could happen, that the DOL's regulation could be stricken, and we wanted to create a good faith defense. Hundreds of providers did that. I'm sure there are thousands, though, that did not. So there's some risk, okay, up until this point in time, where the DOL, what they decided to do, they did not appeal the New York decision. Instead, they issued a new emergency regulation. So clarifying again what a healthcare provider is, saying, okay, New York, you thought we were too broad last time. And what the judge said was you can't, it's not that you're talking about non-medical home care and home health. It's that it's everybody. You're doing it at an organizational basis. You're saying everybody's exempt, including your receptionist and the office staff that doesn't have anything to do with your clients. They don't have any exposure to your clients. You need to be more narrow and just define the caregivers. And this, again, is very, very much a nutshell that I'm giving you in the interest of time, right? But the idea is make it position specific, and that's exactly what the DOL did. So what this means, and hopefully you can see my cursor here. You see how big my cursor is? I did that the other day. I'm becoming blind here. So April 1st, this is the takeaway for you. April 1st all the way to September 16th, right, when this revised regulation went into place. So from this period to that period, if you were using the healthcare provider exemption, it's very likely and possible that it never applied to you or any of your caregivers. And so the failure to provide leave creates some risk of liability in this period. Moving forward, you still need to provide FFCRA coverage. And again, remember, this is if you have fewer than 500 employees, right? And maybe you have that limited exemption if you have fewer than 50. But remember, you know, assuming that the other criteria apply. Now, moving forward, as of September 16th, we're under these revised regulations of the DOL that would apply maybe to some of your employees. So you still are going to have to provide FFCRA coverage to at least your office staff, and maybe you elect to use the healthcare provider exemption or partially use the healthcare provider exemption for some of your employees. Okay, so I'm hoping that makes sense. You should, again, if you're going to use it in any way, I will make the same recommendation I did before, get a legal opinion on that. And I know that the FFCRA, as it stands today, is expiring in a couple of months, but the liability doesn't expire for a couple of years, right? So somebody in 6 months, a year from now, could bring a lawsuit for failure to provide FFCRA coverage, which is why we have these steps. So here's what you should do on FFCRA, then we'll move on. Find out if you're subject to the FFCRA. Look at those FAQs, talk to me if you want, or one of my people, and figure out, does it apply to me? If it does, then you've got to decide, do I want to use the healthcare provider exemption at all, right? Number one, do I qualify as a healthcare provider? Number two, should I use it at all, or should I just provide full FFCRA benefits? If you decide you're not going to provide the full benefit, maybe you're not going to do the family medical leave part, the 10-week part, you don't want to do that for your direct caregivers, then you should probably get a legal opinion on that, right? If you're going to offer it, you don't need a legal opinion because you're not subjecting yourself to potential liability. Make sure that in any of these decision makings that whatever decision you come up with, that you implement FFCRA policies and notices, because remember, as long as you're under 500, the FFCRA is going to apply to someone, maybe just your office staff, but make sure that you're implementing that, all right? And then communicate to your employees exactly what has happened and what decision you've made, and use an arbitration agreement. You've heard me say that many, many times, right? Have an arbitration program where you can avoid a class action, because a single FFCRA case isn't worth that much. It's worth a few $1,000s, right? Think about it. It's 12 weeks, basically at minimum wage, maybe double damages, right? If you don't have a good faith defense, right? And then some attorney's fees. It's not going to be a whole lot of money. That only stacks up and multiplies if you have multiple caregivers that want to sue you or that are part of a class action that did not receive FFCRA. So these are the materials you should have in place. Make sure you have your posters up, the policies. Policies, by the way, not just general FFCRA policies, but policies that deal with the healthcare provider exemption if you're going to use that in some manner, right? Because even if you're not going to use it, you ought to have a policy that says that you think that you qualify, so that you can change your mind later if you need to, right? It's not a guarantee that you get it, but just a decision, a business decision to provide it. So we have a process. I know a lot of you have already used this, where we've got kind of a package is can be part of the toolkit, or can be standalone if you're not a toolkit subscriber. But it's got all the policies and the options and the memos, and we update this stuff, based on the latest definitions. And there's a questionnaire too, if you don't want to try to figure this out yourself. I think it's not that difficult to do, but if you don't have the time, you can fill out the questionnaire, give it to us, and it takes us a couple of hours to put your materials together. Okay, so moving on to the litigation, right? You can see that there has been a trend of of lawsuits that continue to increase. There's been a little bit of a slowdown in that in the last few months, I think, because of the election and what's going to happen with the immunity and qualified immunity. These now are going to pick up. I think we're going to see these accelerate and go well beyond 200 a month. These are just the labor and employment suits, so we're not talking about wrongful death here and some of the other types of claims that don't have to do with employees. When we're looking at the labor and employment kind of lawsuits, retaliation is right up there. You see FFCRA is fourth on the list. FMLA is very related, right, to FFCRA. So you get the sense. I think I have in here, oh yeah, healthcare is the number one target for these. Now, a lot of this is the facilities, right, and the outbreaks we've seen at the facilities more so than home care, but we have seen some home care, and one thing I'll tell you is more from a wrongful death or an injury kind of perspective. If your client gets sick and you hear that and the client's in the hospital or something like that, get as much information as you can from the client and their family right from the beginning about other exposures. Was the client out, right? And there's a contact tracing sort of questionnaire on the toolkit. Get as much information as you can early, because what we've seen, and we've fielded hundreds of these calls from our clients, the client, you're my client, right? So when I'm saying client, I'm talking about the agency, right? The home care agencies call us when this happens, and what's happening is their client goes dark on them after some time, right? You can get information at first, then you don't hear anything for a while. You're not sure what happened. Did the client die? Did they come out of the hospital? And then sometimes there's a lawsuit that's filed. Now, this highlights the need for those recommended protocols and your training and your screening and your documentation. Some companies think that all we need to do is do it and we'll be safe. It's not just about doing it, right? It's about documenting what you have done. And this is just a very typical fact pattern. There's nothing special about this. Somebody gets sick and the family claims that it's the employer's fault, and then they identify that the specific worker of not following the protocols you put in place as the reason that so and so got sick. Insert so and so to whatever client it is, but hey, she wasn't wearing a mask, she wasn't washing her hands, she wasn't social distancing, whatever the case may be. Obviously, the more deaths there are in this facility, and the more you see staff facilities. I'm doing some work right now in California, where a private equity firm is looking to buy a SNF that's got several locations and has several resident deaths, and we're doing analysis on, can we get a indemnification that's broad enough and deep enough to make the purchase worthwhile, right? Should we do this, or is this risk too great? So the more it's multiplied, the bigger of a problem we have. But your documentation is absolutely critical. Absolutely critical. What have you done? How frequently have you trained? Do you have the records of the certification? That people are telling you that they're fit for duty, that they're returning to duty, right? All of those steps, right? All of those things are really, really important for you to be able to document. So like I said earlier, you can meet that standard that, listen, even if my worker was not doing what she was supposed to be doing and wasn't wearing her mask or her gloves or washing her hands when she arrived, all of those things, that's not a lack of training or understanding. Like we've told you in our notices, like we've told those caregivers, they should have been doing that. We wanted them to do that. I'm sorry that hasn't happened. So I just put this up. We, normally in presentations, I'll jump into one or two of these and kind of talk to you about, the depth of all of these. We don't really have time today, but I wanted to at least, kind of put up what pings the radar. And over the course of presentations, I will hit those. I want to talk a little bit about compliance, kind of to the point that I was making, and now I want to sort of take a step back into overall compliance and not just COVID-related compliance. And I think one of the greatest things that has come out of this terrible time in our history is, for this industry, is I mentioned in the beginning that we've had issues in the past with compliance. And I think I was talking to Zach, and this is probably before most of you got on the line. But the reason that I do what I do, I'm a litigator by trade. That's what I do. I litigate cases, right? And I defend my agencies against employee lawsuits that have been filed, and a lot of those are class actions. A lot of those are related to pay practices. And we, as an industry, ever since the exemption changes in 2015, have not been very good on our compliance. And so I'm litigating the same issue over and over again. And the one I was talking to Zach about was live-in cases, right? And people not having their live-in set up the right way. And the way that you guys probably know me, right? Some of you, I train on the franchise systems all the time on this stuff. And I just made a decision. That's where the toolkit came from of, listen, rather than just sit back and constantly defend these cases, right? What we're going to do is we're going to get out and help people understand what they need to be focused on so that the cases stop or slow down and these lawyers move on to a different industry. And that really has not happened yet. We've gotten better, but not at the clip I'd like to see. So we're taking a step up and doing some more stuff, which I'll talk about. I don't think it's in here, but I'll talk about it tomorrow, right, to make it even easier for you, not only from a regulatory standpoint, licensing standpoint, but this labor and employment compliance with all the changes in the laws and everything by creating templates that are very state specific and that are very easy for you to use and such. But this is really important to focus on your compliance, and don't wait until a litigation to deal with it. You're going to have to deal with it sooner or later, either now, right, of really looking under the hood and figuring out what's wrong. Tom, I don't want to embarrass you, but Tom has done an amazing job at doing this. And Tom is not going to have a problem with his agency. He's just not going to have a problem. Tom is never going to spend much money on me. He never will, because he's done an unbelievable job of learning this, of implementing a compliance program, and there's nothing for anyone to sue him over. He does it right. But I'm telling you that most companies in our space, they don't have everything right. And there is a risk, and that risk is much more significant than you realize. There's a lot more at stake than you realize, and it's typically only through the litigation process where a company figures out and says, wow, I did not have any clue how expensive and painful this litigation process is. Now I want you to, come in and kick the tires and fix everything, right? And that's great, but it's a little late. And what it does is I think for everyone else, it sort of continues to push that reputation forward that, well, home care, they're just not that compliant. These companies don't care. That's not it. It's just that oftentimes we don't have the budget to think about it and to do anything about it. So that's why we built the toolkit, is let's make it simple for them, right? If you're not going to hire us directly to do an audit, then at least, get some do-it-yourself type materials, right, where you can educate yourself and put some things in place. So that's kind of the backdrop for the conversation about compliance. So understand the way these things generally work, right? The presumptions are in favor of the employee. If there's a question about what happened and you can't prove as the employer what happened with respect to somebody's time, or whether they had a sleep interruption or a meal interruption, right, or off the clock work, or whether they're exempt or not, if you can't conclusively prove that what they claim happened did not really happen, then you're going to lose, because the burden is on you to prove, even though it's the employee's time and their work and their record, the burden is on you, right? So what you have to do is make sure that you've got a very, very strong backbone in place to actually prove. It's not a question of what actually happened, it's what the caregiver says happens, and can you show that that's not true conclusively through really solid records. So there's various ways to do that, but it really starts with your policies, having really, really strong policies and procedures in place and documentation that will allow you to prove, and then to make sure that your employees are trained on it. So let's take two different ways, right? We'll start with pay practice claims. That is non-exempt, off the clock kind of claims, right? What you want to do there is really analyze your business and figure out, where is there a hole, where do you not have visibility and a record establishing exactly what an employee was doing? If there's an assumption, if there's something missing, right, you've got to put a procedure in place to figure it out. Just an easy, quick example would be sleep time. I litigate sleep time cases all the time, right? Where we're just assuming that you're getting a 16-hour day and you're getting your sleep time, or a 13-hour day and you're getting meals and sleep time, and there's no record that your sleep time isn't interrupted. Just, have a timesheet where the employee confirms that their sleep isn't being interrupted, right? Don't wait and assume that that's the case, because now the employee, a year from now, 2 years from now, could say, you know what, I was actually working 24 hours all the time and I never got any sleep, and you have no record to disprove that, right? So that's kind of the concept. So you're developing evidence with your employee under your roof, right, or under your client's roof, that could be used if there ever is a rainy day and that employee wants to challenge you on something. And so that employee, when that employee goes to a lawyer and explains to the lawyer, yeah, they had me sign this and that, and I was certifying my time was accurate, the lawyer isn't going to bring that suit. You won't even know. Like with Tom, when I'm talking about Tom, he won't even know how many close calls he might have had, or how many things, how many things he avoided, right, by an attorney never even bothering, because there's no point. There is no meat on that bone to eat. I'm going to go over here, right, and target some companies that haven't been through the process, right? So make sure employees understand what working time is, right? Make sure that they know how to accurately record all time. You can't train enough on this stuff. What to do, who to call, right? Having a really good, robust complaint procedure where we say, look, if you have off the clock work, no supervisor can tell you to work off the clock. So if you have off the clock work, I want to make sure you're reporting it to this person by this time, within 24 hours, 48 hours, whatever you want to say, right? And now that absence of the complaint is evidence. You see what I mean about creating evidence? Well, here's the policy. You're saying that you worked through all your sleep time, but you were confirming that you did get all your sleep time when it was happening, and there was a complaint procedure that you never followed. How would we ever know? How would we have known how to fix this? And that employee is forced to say, well, you wouldn't, because I didn't follow your process. So that's the idea. So with all that in mind, let's just take a quick, now getting back to COVID issues, okay? A quick recap, because I know I just threw a lot of information at you, of what are the major things that you want to make sure you have in place to protect against these wrongful death sort of lawsuits, okay? And I'm going to talk for a minute about waivers, if I may, take a little bit of time, because you're going to want to hear what I have to say. All right, communicable disease policy, got to have that, right? And this is not a COVID thing, that's a forever thing. If you didn't have it, you got to have it now, right? The notices to employees and patients, and part of that is when your client and your caregivers know what you're doing and know all the steps you've taken, they feel more comfortable. They're going to work with you more. There's a better consumer confidence. There's a less of a likelihood that they're going to blame you if something goes wrong, right? Client waivers, caregiver waivers. Do we use those? Those are something that's in our response package. That is very state specific. In this business, a client waiver is harder to enforce than if you were at a trampoline park, right? Or you're in Disney World or something like that, and you assume the risk, right? But the caregiver, so you've got to decide, are you just going to notify clients that, hey, there's an inherent risk of utilizing our services, even though we're doing everything in our power to protect you, just by the nature of the services, there's an inherent risk, since it's not you in isolation, and everybody understands that, and you are willing to receive care anyway. With the caregiver, what's called, some people refer to it as a caregiver waiver, they're not waiving any claim. What they're basically doing, at least our waiver, the way it works in our package, is they are saying that my exclusive remedy for any claim that's a work-related injury because I got sick, and I'm saying it happened at the client's home or in the office or whatever, is workers' comp. And that is where you want to be. That is where you should be. That's where you want to be. You've already paid for that. You've already paid for that system. What you don't want is a wrongful death or a negligence claim or something like that, that you now have to litigate, even if you can win it, you've got to spend all this money on it, right, to win and prove that there's not a problem. And that money that you have to spend will be leveraged against you for purposes of settlement. So have them sign the waiver where they're saying, look, I understand that if I get sick, that's a workers' comp issue, and I will proceed in workers' comp. And we're saying the same thing. So will we, right? That's a consideration. And now if somebody brings that lawsuit, we can go and take that waiver and file a motion to dismiss and say, hey, look, this is the wrong form. It works almost like an arbitration agreement. Wrong form. We already talked about this, and we all agreed the exclusive remedy here is workers' comp. So really, really powerful tool to have. It is in your materials if you're a subscriber of the package. So make sure you're applying that. Certifications of lack of exposure every day before there's any client contact, right? Confirming that I'm symptom free. Use the protocols, use the recommended protocols we gave you. That's the latest certification language. It changes sometimes. The CDC changes some things, so make sure you've got the latest and the greatest. Tom, I think one time you asked me, do we notify of updates, and we try to do that. It's hard to do a bunch of red lines in it because then it becomes confusing as to what we can use, and you wouldn't believe some of the things that we've seen when we've redlined things where people are implementing the document with the red line. There's different levels of sophistication when it comes to home care. I know it's none of you guys. You're educating yourself. You're in this presentation, but I'm just telling you, there's some that if I give them a document that says in big bold that says don't use this, they'll have their caregivers sign it, right? So we have to be careful about red lines and the like. Okay, make sure you've got quarantine protocols. If somebody is sick, that there's a confirmation that they're symptom free, right? There's fitness for duty forms and whatnot. Telework program for anybody that's working remotely, so we can define, just like we would in a live-in case, what is work time, what is off time. The FFCRA materials that we talked about. Don't forget about your visitors in the office, right? I think we do a really good job with caregivers and clients. Sometimes we forget about the visitors and just having a protocol. And maybe you don't have visitors, but if you have a protocol, it shows that you thought of everything, right? If we did have visitors, or when we do, we have them also confirm that they're symptom free and sign the visitor declaration form and so on, right? And again, what you're demonstrating is your reasonable efforts to control the pandemic and protect the interest of your caregivers and clients, which is the defense that you need, and also, of course, the right thing to do. Communicate constantly with employees and clients. That contingency planning, change when the events around you require it, right? Make sure that you're nimble, right? Try with your employees in this time where everybody's on high alert and concern, to give them the benefit of the doubt, right? To help them. Maybe you don't know, should they be coming into work or not. Just and again, I'm just not from a legal perspective, this particular thing. The benefit of the doubt is a good thing to do in a very high tense sort of environment where we don't want somebody feeling stressed out or maybe pushing themselves too far. We're not exactly sure if what they're saying is really legitimate, or they're just not wanting to work, right? Let's try our best to be accommodating during this time, and I think that will go a long way in the future. And we have seen good retention. I think we're going to see, because of some of the technological advances, better retention in typically a high turnover industry, as caregivers are realizing how much we actually care about them, how important and essential they are. And of course, arbitration agreements. So I think most of you've got this package, but if you don't, this is the stuff that is in the COVID response package. Again, if you are a franchisee and your franchisor subscribes to the toolkit, you'll already probably have this. They probably have purchased this package. Again, we update this stuff. This can also be a standalone thing. If you don't have it and would like access to it, just text the word Littler to the number 55000, and that will ping Melissa Mann, who you all know and love, to contact you or send you a demo and help you get it. Very easy to do. So I've mentioned the recommended protocols. I love to kind of highlight our folks that have helped with this, and just, you know, very appreciative of these brands for working with us. By the way, in the know there, the caregiver training, they have done a free training on the protocols, basically made turn the protocols into a training. So you can go there and have your management go through that and basically be trained on the protocols. A good idea to do. I forget what the link is for that, but if you can't find it through a search, I think if you put in the know in Littler, it'll pull up. But if you need help, I will get you some help. And here are our supporters. So very grateful and thankful. I really appreciate having the opportunity to talk with you all today. I've got a little bit of time left if we have some questions. So let me stop sharing. I have not, if there's been anything that's come through the chat, I haven't seen it because my entire screen has been covered. But do we have any questions so far? Would you guys like to come off mute and ask any questions to me? Or have you heard enough? Are you through?
Tom, you're on mute.
Well, Tom, let me answer that question. You're still on mute. I can't hear you. And I'm not that good of a lip reader. All right, Tom's working on it. While Tom's working on it, any other questions? Oh, I think, Tom, you're on. There you go. Now try it. No. No, still blocked. Anyone else? Do we need to maybe unmute the? I'm looking here.
He probably didn't pay his bill, Angelo. That's why.
Or maybe he didn't pay my bill. I think
That's what I'm talking about.
Yeah, that's probably what it is. I gotta check with AR here, see what's going on. You could maybe type it in if you wanted. Aren't you still on the phone? We heard you earlier. All right, anyone else with any questions while we're waiting on Tom? There's a little Zoom group chat that we can use. If you guys want to let me off the hook, I got no problem with that. But as mentioned earlier, how often do you get a free lawyer, is willing to stick his neck out a little bit and give you, not legal advice, of course, but little guidance. Tom, I'm trying to unmute you here. I don't think that will matter because you're on the phone. All right, well, maybe what we do, Tom, is you email me your question, which I promise I will get to. If nobody else has any other questions, I don't see anything in the
Angelo, I finally got one.
There we go.
Got through.
There we go. I can hear you now.
So historically, I know Littler's been very good about dealing with the issue of marijuana. And with Arizona, the new regulations are going to come along for us as far as recreational use. And historically, I know you guys have done some webinars on that, and I'm assuming because of the change in the law, it's not going to be just Arizona. So if the powers that be, if you could push that back to your
Sure.
Littler team, if they could have a webinar on something like that.
Yep. Yeah, I will be happy to do that. And we're doing some quarterly webinars, and you guys have seen the industry webinar, so we'll be sure to cover that. And we also do a webinar that's always pretty popular, kind of covering all the state law, which now is just blown up. We spend a lot of time doing those maps and the heat maps that show which jurisdictions have meal period requirements or business expense reimbursement requirements. So we will look to do that, and there's a couple of we'll see how it turns out, but generally speaking, I think what most companies do when there's recreational use of marijuana is they take it out of their drug testing protocols, just because it's impossible to tell, when was somebody, unless you're catching them in the act, right? The fact that they have THC in their system, right, isn't going to necessarily tell you when that occurred, and it could have occurred during off-duty time when it was permissible. So it creates some problems, and there are different approaches that states take. So I will dust that one off, and we'll do that one again soon. Jude, do you have a question?
Yes, sir. Yes, I have a question going back to kind of along the lines, I think something along the lines like the burden of proof is on the agency.
Yeah.
And there's something that I've been on my mind for years now. So we use ClearCare, and when we have, say, like a 24-hour client or a client where caregivers are one's relieving the other, usually, the one clocks in at the appropriate time, the other clocks out at the appropriate time as well. But sometimes, I say probably a handful of times a week, so a couple hundred times a year, we have a caregiver that there's an overlap. It shows in ClearCare, like a 15-minute overlap.
Yeah.
But there really wasn't, for a variety of reasons. So we go in and we manually adjust that person's clock in or clock out time. And it always just makes me nervous. And we're only talking about 15 minutes, but a couple hundred times a year. And you probably have some caregivers that really, say, no, I was here at this time, or I left at that time, and so forth. And so what's the right way of documenting it? So as you go back to saying about that burden of proof, because if someone was to question me about a shift last week, let alone a couple of years ago, we don't know the details of what had happened. So what do you recommend there?
Yeah, I'm so glad you asked that question, because what you just described comes up all the time, and it is a particular problem in this industry, because in this industry we don't have the caregivers reporting into an office, right? So it's harder to get their report. So this is how we deal with it on the toolkit, and I'll give you a variety of different ways. But the key, right, if there's time that hasn't been worked and your time system shows that it has, the assumption is going to be, right, that the time was worked, right, and now it's been adjusted, and that's time shaving. And time shaving is the worst thing that can happen, right? I've had a lot of time shaving cases. I'll tell you about an interesting case in a minute here with prison guards. That always makes me laugh. Big company did this. But what you want to do is you want if it's a legitimate time edit and the person wasn't actually working, what you want to do is have a payroll adjustment form that the caregiver signs, and the caregiver and the supervisor can sign it. You put that in your payroll file, and now you've just changed what could be deemed, and it's exactly what you said, right? That, well, I'm not going to remember, even if I did. If you said the work wasn't done and the caregiver says it was, and only the supervisor edited it, guess who loses in that scenario, right? Because of the burden, caregiver is going to win every time. But if the caregiver has signed off on it, and the reason I said the way we deal with it in the toolkit, we have a form that's called a payroll adjustment form. And what I like to do is tell my clients, give your caregivers 10 of these forms at orientation and just say, hey, if there's ever a time, and this is broader than just your question about a time edit, right? It could cover anything. I forgot to clock out. I forgot to clock in. I clocked in but didn't actually do any work, right? When there, whatever the scenario is, or my supervisor called me while I was clocked out and I couldn't get to my phone to punch in, right? Because I was talking on the phone. That was a 20-minute conversation. I should be paid for that time, right? So the argument that caregivers always make, right, and clinicians is, I used to deal with this a lot on the skilled care side with people that were doing their notes, particularly back in the days when it was a paper note, right, and not an EMR. And they would say, well, we had to leave the sheet, that the time record is with the client, and then we would come home and there was no way to record our time. So we have all this off the clock work. And what we're doing is we're giving you an alternative. So this is our official time record, but if for some reason it's not right or you didn't get time in, use this form. And now if they argue that the time is inaccurate, the lack of the form that's the thing that is your evidence, right? Of you didn't follow the process. And to support your actual edit, right? The caregiver's signature, that's it. And more thing I want to say is people say, well, how are they going to get the forms in? And, that's a hassle.
Yeah.
That's one way. It doesn't have to be anything that's special as long as you have the caregiver validate. It could be an email, it can be a text message, as long as you can prove it up, right? Where we've got the caregiver telling us, yeah, I actually started at 9, or my work ended at 4 and the system has me down at 4:15. So it's okay to go back to 4. That works, right? Because it's the caregiver's record now and not our assumption. So
yeah, I think
great question.
that text makes it a lot easier, because it does seem very labor intensive either way you go about it, but that makes it a little bit easier there. But it always has me concerned if we ever get challenged on that. I don't know how to prove it.
That's it. I'm so glad you're thinking about that and you're aware of that, because I do have cases like that all the time. So let me tell you the little caveat story here, because it's just so funny.
Oh, yeah.
Big company, right? I mean, big company should know better. This is where I thought you were going. And what they would do is the prison guards, they 24-hour shifts, right? And they would come in and out, and the supervisors would have a meeting 7 minutes before the shift change with all the new guys coming in to learn from the guys that have been on shift about what's happening, who's been acting up and what they need to know, right? And then that time would just round away, right? Because it was at 7 minutes. So if the shift change was at 5 o'clock, they'd show up at 4:53, and then their time would round up to 5. So they were always, off the clock, right? And there, was a big class action lawsuit about that, and they lost. And the supervisors and the company is just like, well, yeah, they were on the clock, they clocked in. I'm like, yeah, but if you force them to clock in only where the rounding is in your favor, that's going to be a problem. So
Yeah.
anyway, just it was the whole case about that for years and years and years. And you will potentially have issues with that supervisor modification of time records without the employee approval, and that is extremely common in our business. Unless I've spoken to them and worked with them, just about every agency that I talk to, that's the way they do it, and they're putting themselves at risk.
Yeah. On a personal note, if I remember as well, you're a Georgia Bulldog fan, and
that's right.
I'm a Seminole, so I was disappointed that you guys got beat up by Florida there.
Yeah, between Alabama and Florida, it's been a tough year. I feel like that's always the story with the Bulldogs. That's more so. Behind me are a bunch of Cowboys. I'm a Dallas Cowboy fan first, and your Cardinals beat up on us too this year, but so is everyone else. So what's the difference, right?
Yeah.
But that's unfortunate. Anyone else with any questions before we wrap it?
Angelo,
there he is. There he is.
Hey, I want to thank you for coming on today. I wanted to ask you. I joined late. Did you tell the gang about the toolkit?
I did
Okay.
tell them about the toolkit.
Just want to let them know, and thank you very much for coming to Arizona. Not literally, but coming in via Zoom. So it was a great session today.
Always my pleasure. It's always good to see you. Hopefully that you and I will have a beer soon in person, somewhere or another.
Well, it was almost a year ago we were in Vegas together. That still goes down as one of the most epic events I've ever attended. So
that'll be a story for another time.
Well, thank you. Thank you, Angelo.
All right. Thanks, everyone. I really appreciate your time. Have a good one.
Thanks, Angelo. And real quick here, again, AZNHA wants to thank Angelo for participating today, and a reminder to all of you that if you did miss any of the presentations, they are available on the members only page of the AZNHA website. If you have any comments regarding the series or the topics that we've had for all of you, the speakers, the flow, the format, any feedback whatsoever, please send that to us at info@aznh.org. We've done our best here for everyone during this interesting year, and we hope that we've done very well and represented you all very well, and hopefully that this series was very valuable to you all. But we need the feedback. We need to know from you guys what's going on and how we approach this and how it all turned out for you. So Again, thank everyone for being members and for supporting AZNHA. Thank you again as we approach the holiday season. We hope everyone stays healthy and it gets to enjoy the holiday season. But always remember to stay vigilant and stay safe out there. So thank you all again, and until next time.